Payment or performance. Article 1232. Payment means not only the delivery of money but also the performance and any other manner of an obligation. Article 1233. A debt shall not be understood to have been paid unless the thing or service in which the obligation consists has been completely delivered or rendered, as the case may be. Article 1234. If the obligation has been substantially performed in good faith, the obligor may recover as though there had been a strict and complete fulfillment, less damages suffered by the obligee. Article 1235. When the obligee accepts the performance, knowing its incompleteness or irregularity, and without expressing any protest or obligation or objection, the obligation is deemed fully complied with. Article 1236. The creditor is not bound to accept payment or performance by a third person who has no interest in the fulfillment of the obligation, unless there is a stipulation to the contrary. Whoever pays for another may demand from the debtor what he has paid, except if what he paid without knowledge or against the will of the debtor, he can recover only insofar as the payment had been beneficial to the debtor. Article 1237. Whoever pays on behalf of the debtor without the knowledge or against the will of the debtor can compel the creditor to subrogate him his rights, such as those arising from a mortgage, guarantee, or penalty. Article 1238. Payment made by a third person who does not intend to be reimbursed by the debtor is deemed to be a donation, which requires the debtor's consent, but the payment is in any case valid as to the creditor who has accepted it. Article 1239. In obligations to give, payment made by one who does not have the free disposal of the thing due and capacity to alienate it shall not be valid, without prejudice to the provisions of Article 1427 under the title on natural obligations. Article 1240. Payment shall be made to the person in whose favor the obligation has been constituted, or his successor in interest, or any person authorized to receive it. Article 1241. Payment to a person who is incapacitated to administer his property shall be valid if he has kept the thing delivered, or insofar as the payment has been beneficial to him. Payment made to a third person shall also be valid insofar as it has redounded to the benefit of the creditor. Such benefit of the creditor need not be proved in the following cases. 1. If after the payment, the third person acquires the creditor's rights. 2. If the creditor ratifies the payment to the third person. 3. By the creditor's conduct, the debtor has been led to believe that the third person had authority to receive the payment. Article 1242. Payment made in good faith to any person in possession of credit shall release the debtor. Article 1243. Payment made to the debtor by Article 1243. Payment made to the creditor by the debtor after the latter has been judicially ordered to retain the debt shall not be valid. Article 1244. The debtor of a thing cannot compel the creditor to receive a different one, although the latter may be of the same value as or more valuable than that which is due. In obligations to do or not to do, an act or forbearance shall not be cannot